Seeking justice. Well, if you are facing a dispute, you might be seeking justice. Let's say you signed a contract with a customer to provide catering services and received a 20% down payment. At the end of the event, the customer expressed a great deal of dissatisfaction with the food and service. Therefore, she paid you only half of the remaining amount. You tried to contact her via phone, text messages, and emails, but to no avail. It's a dispute. The customer refuses to pay, and you feel you have been wronged and deserve to be fully paid. Now you're seeking justice. The court is the immediate place that comes to mind to find it. You imagine your day in court. Your case will be heard by a judge or a jury. Witnesses will be examined and evidence presented. The final decision will definitely be in your favor. The customer will be ordered to pay the remaining amount and even your legal expenses. If this is the script that goes through your mind, you're probably watching too many courtroom dramas. In reality, there is a continuing decline in the number of cases that reach the full trial stage, a phenomenon known as the vanishing trial. Thus, in the United States, less than 1% of civil cases get to the trial stage, and in England and Wales, 3%. The decline in the number of trials is mainly attributed to legal systems' endeavors to deal with huge backlogs and achieve efficiency. Courts around the world are promoting faster and shorter proceedings and encouraging parties to settle disputes. These steps are aimed to lower caseloads and reduce costs. But do plaintiffs benefit from the trend of efficiency, time-wise and money-wise? To answer these questions, we conducted a docket analysis of a representative sample of 443 civil cases filed in the Tel Aviv Magistrate Court in the years 2010 and 2011. First, we asked, at what stage are cases disposed of? In accordance with the worldwide vanishing trial phenomenon, more than half the cases were disposed of at the managerial stage before any hearing occurred. About 40% of cases were disposed during the preliminary stage, and only 8% were disposed or following a full trial. Then, we wanted to know how long from filing to disposition. In the managerial stage, proceedings last about 10 months. In the preliminary stage, they last almost 2 years, and in the trial stage, they last about 3 years. So, time-wise, the vanishing trial processes are efficient for plaintiffs. What about money-wise? Amount ratio is the money-wise efficiency measure calculated as the percentage of the received amount from the claimed amount. What is the amount ratio in each stage? Plaintiffs receive 83% of their claim if their case is disposed of before any hearing occurred, whether in a settlement agreement or by default judgment. Disposition of a case in the preliminary stage yields an amount ratio of 46% and only 34% when the case is disposed of in the trial stage. Again, money-wise, the vanishing trial processes are efficient for plaintiff. So, if you face a dispute, you better hold your hopes concerning your day in court. You should aim to resolve the dispute before you enter the court. Proceedings will be remarkably shorter, and the amount ratio will be significantly higher than if you insist on pursuing justice. What about justice? Well, that's complicated.